Like a fiddler on the roof, 17 years on the court. Sounds crazy, no? Look at the 2002 photograph of me in the program. That is proof of the irreparable damage that this job has done to me. Fiddler on the Roof is one of the all-time musical classicals, a play that evokes universal themes as relevant today as when it opened on Broadway in the 1960s. To be clear, I am a Fiddler junkie. As a young teen, I listened to the Fiddler album countless times and to the voice of the great Zero Mostel, who played the leading role of Tevye. Back then, I wondered, why did parents name a young boy Zero? And did he go around with the nickname Bupkis? Like many of you, I have seen the movie and the play. My present law clerk, Joshua, performed in the national tour of Fiddler. And as a young associate at Wilentz, I performed the role of Tevye in a one-person parody at the annual holiday party. More about that at the end of my remarks. Let me begin with some background to the story to inform the discussion of the lessons that we can learn from Fiddler. Fiddler takes place in 1905 in the fictional town of Anatevka, a shtetl, a small village somewhere in Russia in an area designated for Jewish settlements. Russia then encompassed the Ukraine and what is now present-day Poland. The Jews in Anatevka live in an uneasy peace with their Christian neighbors. They also live in fear of a pogrom, state-sponsored terrorism and violence directed at Jewish communities. In 1905, a revolutionary fervor is sweeping Russia. Not even little, isolated Anatevka, ruled by the age-old traditions of the Jewish faith, is far removed from the upheavals of the world about it. The main character is Tevye, a poor milkman who lives with his wife Goldie and their 5 daughters. Tevye pours out his complaints and his heart in an ongoing, unrequited dialogue with God. Now, I have those dialogues too, but the only answer I ever receive is from the Chief Justice. The main storyline revolves around Tevye's daughters and their challenge to the patriarchal tradition of arranged marriages. Tradition is the organizing principle of life in Anatevka, dictating how people dress, what they eat, and whom they marry. Tevye says, "How did these traditions start? I don't know. Tradition. Without our traditions, our lives would be as shaky as a fiddler on the roof." Now, I hope I'm not scaring anyone with my little Tevye dialogue there. By tradition, the father arranges and approves the marriages of his daughters. But Tevye's 3 eldest daughters want to choose whom to love and whom to marry. Tevye arranges the marriage of his daughter Zeidel to the wealthy butcher. But Zeidel is in love with a poor tailor. Tevye makes the first exception to the tradition of paternal privilege. He bends for the sake of his daughter's happiness and gives his permission and blessing for her to marry the poor tailor. When Hodel, his second eldest daughter, announces that she and her boyfriend, a young revolutionary, intend to marry, she does not ask Tevye for his permission, just his blessing. And then Tevye ponders over the unraveling of his patriarchal prerogative. He says, One little time I pulled out a thread, and where has it led? Where has it led? And then he gives his blessing and his permission for them to marry, because he knows they are in love. When his third daughter, Chava, tells Tevye she has married a young Christian villager with whom she has fallen in love, tradition has reached a breaking point. For Tevye, marrying out of the religion is an existential threat to the Jewish faith and to his entire belief system. As Chava begs his acceptance, Tevye engages in this dialogue with himself. Accept them. How can I accept them? Can I deny everything I believe in? On the other hand, can I deny my own daughter? On the other hand, how can I turn my back on my faith, my people? If I try to bend that far, I'll break. On the other hand, there is no other hand, no Chava. And then we hear the chorus of tradition. Tradition commands that Chava is dead to him. Not even tradition, however, can extinguish his unspoken love for his daughter. At play's end, Chava comes to bid him farewell. And although Tevye will not acknowledge her, he says quietly, under his breath as she leaves, God be with you. However insulated Anatevka may be from the world, it is not immune from the political and social spasms shaking Russia, nor immune from the latest wave of anti-Semitism. First, the village suffers a mini pogrom, and later the local constable, the prototypical Russian apparatchik, announces that the entire Jewish population of Anatevka must pack up and leave. So Tevye loads his meager belongings onto a cart, and with Golda and their two youngest daughters, they set out on their journey to America. So what can we learn about from Fiddler, about tradition, persecution, and immigration? Let's begin with tradition. We have our traditions in the law. Why do lawyers say, "May it please the court," when they know what they're about to say is not going to please the court? Tradition. Why, when I come on the bench, do I take the seat to the immediate left when I really want to sit in the best seat in the House, front row center? Tradition. Tradition allows us to share common and cherished values, infuses meaning into our mundane lives, and guides and comforts us in our daily ways. Tradition brings predictability and conformity, but it can also oppress. Tradition has been the rationale for repression and discrimination throughout the ages, a justification for a privileged class of people keeping downtrodden a disfavored and powerless class. At the time of the founding of our republic, women did not sit in the Continental Congress or the Constitutional Convention, nor were they able to fully participate in civic affairs. Tradition. African Americans were enslaved and later, when freed, denied their civil rights as equals in society. Tradition. Many odious traditions have been codified into law. The struggle of women and African Americans, and now the LGBTQ community, to attain equality in our society in many ways has been a struggle to overcome tradition. Certain traditions may be central and sacred to a faith, a creed, a way of life. But we learn in Fiddler, as we do in life, that tradition cannot hold back the irresistible power of love. What is the role of the democratic process and the judicial process to alter traditions codified into law that discriminate and oppress and deny persons the right to marry whom they love? To alter a tradition codified into law, whether through the democratic process or our judicial system, takes time and an enlightened public. The immutable principles in our Constitution tell us that the government cannot deny a class of people the equal protection of the laws or due process. But such principles are tested in the real world. Our inalienable rights depend on an enlightened public and courageous courts. However, courts often will not bend to tradition to protect the rights of a marginalized or disfavored class of citizens unless there is a critical mass of public support. That has been true about the right to marry. In 1967, the United States Supreme Court invalidated Virginia's criminal statute banning interracial marriages, and in the process, a similar ban in 16 other states. Chief Justice Earl Warren wrote, "Under our Constitution, the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the state." By that point, the cause of civil rights had won acceptance in Congress, in our courts of justice, and in the court of public opinion. The majority of people did not believe that laws banning interracial marriage accorded with our contemporary values. But the United States Supreme Court had the opportunity to pronounce Virginia's statute unconstitutional 12 years earlier. In 1955, a Virginia couple, a white woman and a Chinese man, married in North Carolina. When they returned to their home state of Virginia, the Virginia Supreme Court ordered their marriage dissolved. Ultimately, the United States Supreme Court declined to review the case, not because the justices believed that the Virginia law was constitutional, but because of the timing. Just 3 years earlier, the court struck down the separate but equal doctrine in Brown versus Board of Education. The justices feared that invalidating the ban on interracial marriage at that moment might incite violence and impede the enforcement of the integration of public school systems throughout the South. In 1955, despite the Brown decision, not a single black child attended school with a white child in 8 states in the South. The court waited for another day when public opinion ripened before undoing the tradition of white supremacy codified into the marriage laws of the South. In 2015, the United States Supreme Court in Obergefell v. Hodges held in a 5-4 decision that the 14th Amendment's promise of individual liberty guaranteed the right of same-sex couples to marry. But consider this. During a good portion of the second half of the 20th century, gays and lesbians were barred from holding many positions in government and barred from serving in the military. The police targeted them, and our immigration laws excluded them, and many states criminalized same-sex intimacy. Indeed, in 1986, less than 30 years before Obergefell, the United States Supreme Court in Bowers versus Hardwick held that the Constitution conferred no right of privacy to same-sex intimacy and upheld the laws of 25 states that made it a crime. What happened between those years to bring about such a revolutionary change in the traditional definition of marriage codified in the laws of every state? The language of the 14th Amendment did not change. The nature of the injustice did not change. Instead, the public's consciousness of the injustice perpetrated by tradition changed. For one, a committed civil rights movement took shape in the 1970s. In the next 40 years, society gained a better understanding of the rights of members of the LGBTQ community to live and work as equals in our society. Through greater public awareness advanced by popular culture and the media, society began to fasten onto an undeniable truth. The people in the LGBT community are our mothers and fathers, our brothers and sisters, our friends, our coworkers. During this period in New Jersey, comprehensive legislative enactments and judicial decisions, step by step, extended protections to the LGBT community, making it unlawful to discriminate against individuals on account of their sexual orientation. The United States Supreme Court slowly took up the march. In 1996, it struck down an amendment to the Colorado Constitution that codified the right to discriminate based on sexual orientation. In 2003, it overturned Bowers. In 2013, it invalidated the Defense of Marriage Act, which barred federal recognition and federal benefits to same-sex marriages that states had made lawful. Then followed the 2015 Obergefell decision, which guaranteed the right to same-sex marriage. As Tevye says, pull one thread, and where has it led? And this is where it led. By 2015, the critical mass of public support had been reached. The District of Columbia and 16 states, including New Jersey, had already legalized same-sex marriage. In a perfect system of justice, our rights should not depend on public opinion or the sentiments of the time. Equality should not take generations to achieve. But consider Justice Kennedy's words in Obergefell. The nature of injustice is that we may not always see it in our own times. The generations that wrote and ratified the Bill of Rights in the 14th Amendment did not presume to know the extent of freedom in all its dimensions, and so they entrusted to future generations a charter protecting the right of all persons to enjoy liberty as we learn its meaning. Did blacks not know the nature of injustice in the 100 years between the passage of the 14th Amendment and the recognition of their civil rights by legislation and judicial decrees? Did gays and lesbians not know the nature of their persecution in the years before their rights were recognized? The simple truth is that constitutional guarantees may not be guaranteed unless there is a critical mass of public support for the rights of a disfavored class. Alexander Hamilton conceived of an intrepid judiciary protecting our rights. But courts do not operate in a vacuum. Judges may be affected by the same prejudices and traditions that blind their fellow citizens. Yes, courts can and should lead the way in protecting our rights, but a critical mass of public support often is necessary to strike the death blow to a long-held tradition that oppresses. The promise of our Constitution depends on an enlightened public. Every successful civil rights movement has educated the public about the nature of the injustice while seeking vindication in the courts. The majority and dissent in Obergefell battled over whether the democratic process or the judicial process was the appropriate forum to end a historically and religiously recognized tradition codified in the laws of our states and nation. In his dissent, Chief Justice Roberts viewed the five-member majority as usurping the democratic process by invalidating the marriage laws of more than half the states. He rhetorically asked, "Just who do we think we are? Who do we think we are?" The majority in Obergefell gave its answer by saying that we are a humane nation with a national charter that guarantees liberty and equal protection of the law to all, even to those marginalized by tradition solely on account of their sexual orientation. Who knows, today, with changed attitudes and tradition, even Tevye might accept an interfaith marriage of his daughter. That's if he's in the reform or conservative movement. Let us now talk about persecution immigration. The persecution of Jews strengthened and reinforced their traditions, traditions that fortified them against the hostile world. Compelled to live within their insular communities, Jews clung tightly to their faith and married within their religion. In some sense, assimilation has posed a greater threat to Judaism and religious traditions than persecution. When Tevye is told by the constable that he and the villagers must leave their homes, at least they have some place to go to escape the persecution, the pogroms, the terror, the indignities. They can go to America. From 1881 to 1920, tens of thousands of Jews died in pogroms in Russia, and another 500,000 were left homeless. No wonder that between those years, 1.5 million Jews immigrated from Russia to the United States, and another 1.5 million to other places, such as Palestine and parts of Europe. During those years, the United States did not restrict the number of immigrants entering into the country, except for the Chinese, who were barred by the racist Chinese Exclusion Act of 1882. The words on the pedestal of the Statue of Liberty, "Give me your tired, your poor, your huddled masses yearning to breathe free," were not empty words or a forlorn hope to a threatened and persecuted people who were milkmen and common laborers. Between 1880 and 1920, our doors were open not only to the well-educated, the well-connected, the highly trained, yearning to score big in America. Tevye and his poor family and other such families, and not just Jewish families, were welcome. The open immigration policy, which allowed Tevye and others to seek sanctuary in this country, ended when nativist and populist sentiments took hold in the 1920s. In 1924, Congress passed the National Origins Act, which restricted the annual number of European immigrants to 150,000 based on a quota system. It also passed the Asian Exclusion Act that all but banned immigrants from anywhere in Asia. How would Tevye and his family have fared as a Jewish family in Germany seeking refuge in this country in the 1930s? Between 1933 and 1940, which includes the period after the onset of the Second World War, the United States allowed in little more than 100,000 immigrants fleeing Nazi persecution, a pitifully small number compared to those who sought sanctuary here. The State Department tightened visa restrictions even as German Jews faced intolerable repression and persecution. In 1938, the State Department admitted 10,000 fewer Jewish immigrants than allowed by law. That was the year of Kristallnacht, the night of the broken glass, when a German state-sponsored pogrom led to the deaths of nearly 100 Jews, the arrest of approximately 30,000 Jews, and the destruction of approximately 1,000 synagogues and 7,500 businesses, Jewish businesses. In the spring of 1939, just 6 months after Kristallnacht, the United States government turned away the luxury liner St. Louis, carrying 937 Jewish refugees, including 400 women and children, despite the anguished pleas of the desperate passengers. Eventually, the passengers were received in various European countries. But after the outbreak of war in 1939, Nazi Germany occupied most of the European continent. At least 251 of the passengers of the St. Louis perished in Nazi concentration camps. During this period, closed borders for Jews was the equivalent of a death sentence. The book of Exodus reminds Jews that they were once strangers in a strange land and to embrace the strangers among us. All of us, Jews and non-Jews alike, are the children of immigrants, however many generations removed. All were strangers once who came here to escape religious persecution or other forms of oppression, or who came here in search of a better life and to experience freedom. This country, a land of immigrants, has opened its arms to the Tevyas of the world, the homeless, the tempest-tossed. Let us not forget that immigrants have made our nation not only the most diverse, but also the greatest on earth. Fiddler is a musical, so it is fitting that I should end on a musical note. While an associate at the Wilentz firm, I played Tevye in a parody called Fiddler of the Firm. The storyline was about the struggle of the oppressed associates to get to the partner land. Are there any associates here in this audience? Okay. If there are, this is for you. So here's a little piece of that performance with an update. Dear God, you've made many, many associates. I realize, of course, it's no shame to be an associate, but it's no great honor either. Would it have been so terrible if I were a partner? If I were a partner, all day long I wouldn't write a brief. If I were a shareholder, I wouldn't have to work hard. Every day would be a holiday. Diddle, 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 dum. I would ride around in a great big Mercedes with a sunroof and a fancy stereo. I'd arrive at 10 and be gone at the strike of 3. I would surround myself with a dozen paralegals and a couple of associates just for show. And everyone would say I'm in the know. If I were a justice, now that would be a miracle of miracles. Wonder of wonders, miracle of miracles, the gov took a lawyer from Willents, put him in robes, and miracle of miracles, named him to be a justice. I think my 20 minutes are up. I just got... I do not do bar mitzvahs or weddings, but I do take petitions for certification. Thank you, l'chaim, and enjoy the rest of the program. Thank you very much. Thank you.